Welcome to the Scaringi Law Lunch Break. This is the time of day to learn a little bit about the law while you enjoy your lunch. Yesterday, September 14th, 2020, Judge William Stickman of the United States Court for the Western District of Pennsylvania issued an order in the case called the County of Butler, among others, versus Governor Wolf. This is another case, like the cases Scaringi Law has currently pending before the United States Court for the Middle District of Pennsylvania and the United States Supreme Court, in which Pennsylvanians have challenged the constitutionality of Governor Wolf and Secretary Levine's business closure, stay at home, and other COVID-19 restrictive executive orders. Judge Stickman's decision is 66 pages long, so I'll try to break it down as succinctly as I can. The part of this decision by Judge Stickman that affects the people of Pennsylvania right now is this. The judge declared that the orders imposing limitations of 25 persons for indoor gatherings and 250 persons for outdoor gatherings violates our right to assembly guaranteed by the First Amendment to the United States Constitution. Thus, the judge declared what he refers to as the congregate gathering limitations to be unconstitutional. This order has statewide and immediate effect. Thus, as of yesterday, the governor cannot enforce his congregate gathering order anywhere in Pennsylvania. The governor stated today that he will appeal and fight this decision all the way to the United States Supreme Court if necessary. More particularly, the governor will file an appeal in the Third Circuit Court of Appeals and will file a request to stay, that means stop or pause, the legal effect of Judge Stickman's order pending his appeal. We expect these filings very soon. But it's unlikely Judge Stickman will grant a stay of his own order. If Judge Stickman denies the stay request by the governor, then the governor will file a stay request in the Third Circuit Court of Appeals. A court must grant the governor's stay request for it to be effective. However, none of that has happened yet. Thus, at least as to the limitations on congregate gatherings, the 25-person indoor limit and the 250-person outdoor limit, the people of Pennsylvania are free from those orders and limitations and are no longer under any legal compulsion to comply with them. Now, some have asked about the business occupancy limits of 25%, 50%, and 75% that apply to Pennsylvania businesses. The limits restricting the number of persons permitted in a business location as a percentage of the local occupancy limits are still in effect. According to Judge Stickman, they were not a part of the lawsuit. Now, we have challenged these occupancy limits in our suit, William Benner versus Governor Wolf, which is still pending in the United States Court for the Middle District of Pennsylvania. In any event, all Pennsylvania businesses are still under the occupancy limits. Now, some have asked about the mask order. The mask order was not a part of this lawsuit. Thus, the mask order is still in effect. Some have asked about the school athletic events. The indoor and outdoor gathering limitations imposed by Governor Wolf and Secretary Levine are now unconstitutional and unenforceable. Thus, there is no legal impediment to Pennsylvania school districts refusing to comply with these orders. However, the attendance limitations on school athletic events have also been imposed by the Pennsylvania Interscholastic Athletic Association, PIAA, and the Pennsylvania school districts, none of whom were defendants in the lawsuit. So the judge's order, Judge Stickman's order, does not compel the PIAA or school districts to remove the limitations on gatherings for sporting events. So these limitations imposed by the PIAA and the school districts are still in effect. The PIAA stated yesterday We haven't had a chance to have a legal review of the opinion, and we'll discuss this with the board at our next meeting. PIAA's next board meeting is tomorrow, Wednesday, September 16th. We hope the PIAA takes the position that the congregate gathering restrictions have no legal basis and thus discards them. But we can only wait to see what the board of the PIAA does. I'll tell you one thing, I strongly urge the PIAA to rescind its congregate gathering limitation policy. Otherwise, it will almost certainly have a lawsuit on its hands. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.